Okay, we're in business.
Ready?
We are.
All right. Ready?
I am ready if you are.
Yes, so.
I'm ready. All right, so we're going to jump right into exception-based processing, denied claims. So we will start with rejections, which I'm sure most of us are familiar with, but a claim is rejected when the health plan cannot process the claim for payment for a number of reasons. So it could be that they can't identify the patient, they were ineligible on the date of service, or non-compliance of billing requirements from the provider. So we will hit claim review, and then on the right-hand side, it will tell you what some things would cause a rejection. So patient name of birth, ID number, date of service, insurer's name, etc. Next. So if you hit that example, it's going to give you an example of things that don't match. This one happens to be for a Medicare claim, saying that the patient's name and the health insurance number do not match what's contained in the Medicare common working file. So that would cause the claim to reject from Medicare. Okay. So and then the claim is returned to the provider. After the initial check, the claim is reviewed for additional information, and it will continue to be rejected if it doesn't meet the requirements. So these requirements answer the questions below, and then you would see that, is it covered by the policy, medically necessary based on diagnosis, and were the authorization requirements followed? Oops, wrong button. Okay. So there are different types of denials. So a claim is denied if it passes the rejection criteria. So a rejection never makes it to the payer, gets rejected at before it's in the payer portal. So if a claim looks like it's submitted and then you can't find it on file and it may have been rejected, that's why it's important to work your rejections timely. But a denial actually passes that and gets denied at the payer. And the denial could result in partial payment, delayed payment, underpayment, or no payment at all. So if you click each denial type, it will tell you the different types of denial. So you have a technical denial. These are based on missing or incomplete claim information, and they could be a number of those reasons. So no authorization, continued authorization, no continued stay authorization, exceeded frequency limits, etc. Technical denial could be for a portion of the care or the entire stay. So I'm sure some of us have seen where there's partial payments based on authorizations received, like therapy, you got 15 authorized, but the patient went 17 times. And the technical denial is issued when, so here's an example of a mammogram screening being performed more than once within a 12-month period. Okay. Clinical denials. These denials are associated with the care or service provided, and they could include the following. So there's a list. So you have your diagnosis code doesn't correspond with the procedure, the service is not medically necessary, carve-out days, inappropriate level of care, and then your coding is incorrect for procedure performed. And then your underpayment. So this is when the health plan does not pay the agreed contract amount, and the challenge with this denial is not always recognized during payment processing, especially if contractual adjustments are not posted at the time of billing. And then here's your example. The health plan pays based only on a fee schedule amount when the provider's contract includes a percentage of charge rate for the particular revenue code billed. Oh, sorry, I'm like clicking my own and getting confused. Here we go. Outpatient reasons for denial. So patient accounting has responsibility to identify and communicate claim denial trends to clinical and operational departments, and then work with these departments to address and reduce overall denials. So in order to be successful, patient accounting must have a method for identifying and monitoring the denials for effective process and reversing and eliminating denials. So tracking and trending the reasons for denials is very important. So we can click the little list here. So here's just a list of, denial trends or, denials that may be trending in your facilities and how you would, write them out. So we don't have to go through every single one, but these are the reasons of denials for outpatient. And then here's an example, like a wrong insurance plan code would get denied. And then here's the same for your inpatient. Some of the previously mentioned denial reasons also relate to inpatient services. So in addition, inpatient denials can occur. So here are your inpatient denials. A lot of what we see is like the first one, it was billed as observation, but should have been admitted and billed as an inpatient, not medically necessary, admission notifications not completed, etc. Okay. Denials in the patient-centric revenue cycle. So these denials can be a result of the pre-service, time of service, and post-service activity. So way back in week 1 or 2, we went over the patient-centric revenue cycle. So now it's all tying together that if you don't do it right in the front, you get more denials on the back end. So we click each service. So you have your pre-service denials. So this type of denial is associated with physicians, patient access, financial counselors, and case management. And the reasons below could be your not ensuring authorization, clinical information not called in for the certification, insurance benefits not verified, and so on. So basically a lot of your registration information. And then you have your time of service denials. Come on. So this type of denial could be new technology used without determining coverage, charges bundled or unbundled incorrectly according to the plan, patient acuity level changes but type of service not changed, admission notification not complete, and then, your patient is admitted as an inpatient but should have been observation, and I'm not going to read the whole list to you, but just, make a note and have these handy when you take your test there. And then you have your post-service denials. So these are a lot to do with late charges entered after your suspense days, multiple claims sent with dates of services that overlap, or you didn't submit the claim in a timely fashion. So depending on the health plan, they have their own timely filing rules. And your contract in-house could change that, but. Okay. So then you have your recovery audit contractors. So the mission of the RAC is to protect Medicare from fraudulent and abusive billing. So the primary responsibility is to identify improper payments for Medicare Part A and B claims that have been paid and processed.
If you are not familiar, sorry, Christina, for jumping in. If you're not familiar with the Medicare Recovery Audit Contractors, the RACs, then you really want to make sure you jot this down, that their primary responsibility is to identify improper payments for Medicare Part A and Part B, because that is one of the questions I've seen often come up.
Thanks, Christy. So we'll click each arrow. So RAC identify improper payments, what Christy just said, and then the claims processing contractor adjust the claims to reflect the proper payment amounts. And then if the improper payment is an overpayment, the claim processing contractor sends a demand letter to the provider to recover that payment. Okay, so then you have the impact of, impact of denials on the patient-centric revenue cycle. So denials have a significant impact on the revenue cycle, which I'm sure we all are very aware of. And loss reimbursement and increased collection fees are obviously the most obvious impacts. Productivity is also impacted, so you need to repeat a process, make corrections, set aside time to research, maybe send appeals, and then make phone calls or pull documentation to initiate that appeal. So we click the example, it's just going to give you an example of what the denial is, and then here's the cost of the denial. Okay. So manage details on revenue cycle. So reports are an essential tool used to effectively manage denials. Recorded on those are the denial information. So you have your denial type, the origination, the source of the denial. I don't know, sometimes I can't say words after a long day. And then your denial frequency. So the reports are used to analyze the denial reason and then to make changes to eliminate the future denials. So you want to track and document the appeals, and then you want to track the outcomes as well.
And this is Barbara, I just want to add, like, it's very important for your compliance program to track denials, because if you're making the same mistakes over and over and over again, and you don't do anything to fix them, that will trigger an audit from any one of your payers.
Thank you. So reduce or eliminate rejections and denials. Practices that help to reduce and eliminate the rejections and denials include, so we will start with pre-service. So this is just kind of going over what we learned in the pre-service section. So I'm not going to go through it in great detail. Just make a little mark on this page so you can refer to this little circle. So here's your pre-service data that you want to make sure you gather and that it's complete and accurate. And then at your time of service, you want to provide the services and monitor the patient services. And then for your post-service, you want to do all your pre-bill edits and categorize and analyze and so on and so forth. So just make a little mark on this page so you can just refer back to it. Oh, activity. Which clipboard list practices that help to reduce or eliminate rejections and denials? Oh, I'm doing it on mine. The left one. It's like just spinning. Oh, you have to submit. I'm such a dope. Okay, we got it right.
Yeah, sorry, I didn't understand the little radiate.
No, me neither. And then I didn't submit until I was like, why are we both spinning? Because I have it open on my computer too. All right. So we'll go into denial management appeals. So just make a mark. This is a definition, and back to Kirsty's point, sometimes they just throw in definitions and ask like what's an appeal or an appeal is. So just make a little note of this so you have it on hand. So in healthcare accounting, denotes a request from a physician or clerical worker in a healthcare facility or third-party payer to reconsider a decision about a disallowed claim for compensation. So just highlight that. All right. So we will click the appeals diamond, and the beneficiary appeal is any individual enrolled in Medicare dissatisfied with the government's claim determination is entitled to reconsideration of the decision, a hearing, or judicial review of the final decision after hearing. So, did we lose Christy?
No, I'm here.
Oh, okay. Yeah, it's the orange, yep, and then just beneficiary, yep, sorry. So then below are the
I didn't track poop all through the house, did I? Because somehow I ended up with a bunch of cat poop on my.
So if the dispute is over whether services provided under the hospital insurance program are covered by Medicare, or about the amount Medicare says it will pay for those services. So these are reasons as to why the beneficiary can appeal on their own behalf. So maybe just make a little note. I'm not going to read them all in full because it's kind of like you have to know the numbers if it comes up in a question. So just make a note. I'm not that familiar with the Medicare beneficiary appeal process, so if anyone has anything to add, feel free. I'm just not that familiar with it. So the 5 level of provider appeals. So the first level is a redetermination by a Medicare administrative contractor. Level 2, reconsideration by a qualified independent contractor. Level 3 would be your administrative law judge. Level 4 is the Medicare Appeals Council, and then level 5 would be judicial review in the U.S. District Court. Again, you don't need to memorize these, just make a little note if they come up on the exam. Okay, next. Waiver of liability refers to a provision established by Medicare to protect beneficiaries and physicians from liability when services are denied as inappropriate or medically unnecessary. Click the markers. All right, so the provision knowledge, if the Medicare beneficiary had knowledge or should have had knowledge that the services billed were not covered, the beneficiary is liable for paying for the services. If neither the beneficiary nor the hospital knew or reasonably could have been expected to know that the services were not covered, Medicare is liable for paying the claim. And then the provision liability. Again, you don't need to memorize these, just know where to look if they ask. If the provider should have known and the beneficiary is protected from the liability, then the liability falls with the provider. And the hospital cannot bill for services other than deductibles and coinsurance amounts, even though Medicare payment has been made, even though no payment has been made. Okay. Appeals process. So the beneficiaries, physicians, and suppliers have extensive rights to appeal individual coverage determination made by Medicare. So the rights are listed in your Medicare handbook, the EOB, the Medicare summary notice, which is also sent to your beneficiary, and then notice is given to patients when they're admitted to the hospital. Okay, so there are 5 levels in Medicare fee-for-service appeal process for both beneficiary and providers. So this is just reiterating what we just spoke of, so just keep it handy. It just lists them out in a different way, level 1, 2, 3, 4, and 5. And then if you click on this, there's your national policy. So if there's no national policy, where there is no national policy, beneficiaries and providers may appeal to the local claims processing contractor. So under Part A, providers can appeal denials based only on medical necessity, and under Part B, physicians and suppliers have the same right to appeal as beneficiaries if they accept assignment on a claim. So accepting assignment means that the physician and suppliers accept what Medicare pays as payment in full without billing the beneficiary for more than the allowed copayment and deductible. Okay, non-governmental claim denials. So for non-government claim denials, providers must follow the appeal conditions specified in the individual plan contract. So sometimes the appeal requirements are provided in the contract, and if it isn't clear in the contract, the appeal requirements can be obtained from the health plan that issued the denial, because we all know how easy that is. All right. So here we have the appeals. So appeals must be submitted within the time frame outlined in the contract. An appeal to the health plan's chief medical officer may be pursued as an appeal of final and last resort. Patient account staff obtain the assistance of the beneficiary. So they can obtain the assistance of the beneficiary if proper authorization is obtained from the patient to facilitate the appeal process. And if the patient account staff is experiencing difficulty, they do sometimes enlist the patient. In all situations, the patient's information must be maintained in a confidential manner. Checkpoint. Which option is not a type of denial? And that is contractual adjustment. And then there's your key points to remember. I'm on still, right? All right. So we have a follow-up workflow, the payment cycle. So the clean claim payment cycle should be determined for all major health plans. If timely payments are not received, so like Medicare clean claims pay within 14 days, a real-time electronic work list should be queued to initiate immediate follow-up action. So additional follow-up will be queued based on the initial follow-up response when primary payment is received and then compared to the expected reimbursement. Any contractual adjustments are posted, and then if there's any patient responsibility or secondary, goes to the secondary and or the patient, depending on what their insurance is. So we know what a clean claim is. A clean claim for a clean claim is submitted to a third-party payer that has all the information and documentation required for the payer to either pay or deny. And your electronic work list is some claim processing and accounts receivable computer systems include functionality that identifies claims that remain unpaid for a specific number of days from the bill date. Unpaid claims that meet criteria are presented via the computer software in a work queue, and the staff will review and work and take the appropriate follow-up steps. So you have your effective follow-up methods and actions. So in addition to your real-time work list to identify claims that haven't been paid, there are a number of claim follow-up tools and techniques that can be used. So you have your health plan electronic claim status. A lot of the larger health plans accept claims directly from the provider or through a clearinghouse, so you can use their payer portals to get the claim status. The second one is clearinghouse claim tracking. So if a clearinghouse is used to submit claims, daily claim transmission files are confirmed and payer acceptance of individual claims is often available. And a lot of times this is where you see your rejected claims. So these should be looked at daily, if you bill daily. And then your Medicare Common Working File is a host of a host that houses all beneficiary claim history and entitlement information. So that'll give you what the patient's eligible for, what they're not eligible for, if they have A, B, C, and D, or if they have a Medicare HMO, or there's an open workers' comp or no-fault claim. And then you can also get your claim status from there. So your follow-up workflow. Most organizations have a policy specifying when an unresolved third-party clean claim becomes the patient responsibility. For example, if it takes 60 days from initial bill date, unless prohibited by a managed care contract or applicable state and or federal regulations. So click August 1. So then if you click August 15th, then October 14th to further explore shifted financial liability. The account's financial liability will be shifted to the patient and processing will be continued according to patient liability billing and follow-up guidelines. Disputes between the patient and the responsible party resulting in undue or unreasonable delays or refusal of payment will now become the responsibility of the patient for full and prompt payment according to the patient liability billing and guidelines. Effective receivables management includes analyzing the billing and collection process and eliminating unnecessary steps and system delays. So if we click the image, so your priority should be set for follow-up. Typically 15 to 20% of accounts make up 80% of the accounts receivable dollars. So you should focus on your high dollar balances to quickly reduce the receivable. To ensure work is being completed, real-time work in process reports should be tracked with standards set for productivity and quality. And then techniques used to impact payment turnaround. So use electronic claim submissions, send hard copy claims via overnight mail or same-day courier. Just mark this page because, ironically enough, that's a question. Send high dollar hard copy claims via registered mail with required attachments until the until the electronic attachment standard is implemented, and then closely monitor payment timeliness and backlogs of major health plans.
And to Christina's point, this slide is a little anti-intuitive for what most of us do in the business. Most of us rely right now on the electronic transmission of claims and whatnot. But these are some tactics that an organization may use, especially if they have incredibly high dollar claims. Think of an extended inpatient stay, things like that. You may take on other tactics to get that information to payers.
Right. And then you have your key focus areas. So the following are additional focus areas, which, if not properly managed, can result in delayed account resolution. And then here are is your list. I know, I'm sure a lot of us see late charges. Okay. So liability payers, I'll confirm liability payer has primary responsibility to pay for healthcare services. And these are workers' comp, automobile medical insurance, which would be your no fault. And then this insurance covers accidents that happen on a business or individual's property and covers visitors, employees, and animals. And then here are your liability payer issues. If the health plan is billed, the claim must include occurrence and value codes identifying the claim is accident related, and the health plan may process the claim for reimbursement and subsequent pursue payment from the liability payer. And then Medicare allows providers to submit liability claims after a 120-day waiting period. In our activity. Where'd it go? So you want to cancel the auto insurance claim. Okay. So liens, a lien is a claim against real or personal property that secures payment of a debt or performance of some other act. A lien gives a creditor the right to have his or her claim satisfied from that property that is subject to the lien before the property can be used to satisfy the claim of general creditors. In healthcare, liens are typically used to secure payment from motor vehicle accidents and other liability claims, and they're treated in different ways. So the first one would be an agreement. I'm not going to read everything in the interest of time. So then this is a lien by agreement. And then you have your judicial, and this is the judicial lien process. And then if you just note these, it doesn't go into too much detail on the exam, but just so you could know it. And then by statute. Okay, checkpoint. Which option is not a lien type? Subrogation. Continue. Next. Okay.
And just to note, when you're, I know we're not going through the key points to remember because we've already, we've just gone through it, but when you're getting ready to take the test and you're actually, kind of doing your last studying, those key points to remember at the end of each chapter will really help you kind of highlight the key points, which is, what it's called, but they're a good review to go through.
So Christina, I was assigned this section. I don't know if you wanted to do it or you want me to do it.
You could do it if you'd like.
Thank you.
It's not my strong point.
Okay, I'm an accountant, so I'll get through it though. Except for I have an echo, and I don't know if it's my computer or not.
I'll mute myself in
Oh.
the event it's me, and let me know if it's better.
Can you guys hear me?
Yeah, I can.
Okay. So, and of course I'm on a delay too, so I gotta look at another computer while I do this. Patient open balances, that's our self-pay after insurance pays, so it could be our deductible, copay, or co-insurance. And this activity will kind of go through some of the processes associated with that. Our financial assistance policy, which is used for evaluating, or we need to identify and evaluate what is bad debt versus what can be charity care. And our financial assistance policy is used for the charity care aspect of the receivable. If you recall, we went over the difference between bad debt and charity care in a previous session, where bad debt is they don't want to pay and financial assistance is when they can't pay. And you have to make sure you have a policy in place before identifying anything as a charity care account. And here are some more key elements of a financial assistance policy. I'm not going to go over all of them, but you need to make sure that your policies do address all of these. And it does come up in our activity in the next step. So what is required in a financial assistance policy? The hospital's mission statement is yes. The guidelines for bad debt or previous unpaid accounts is true. Installment arrangement guidelines is true. Payment methods is true. Procedure charge is false. Registration record is false. And clearly defined a financial assistance statement is true. Yay, we're experts. So again, recognizing the difference between bad debt and financial assistance or charity care. Make sure that you have a policy that establishes the criteria and the processes that you'll use to enforce the policies. So here's some aspects of the financial assistance. Each one of these are dots that you click into. So poverty guidelines, they all specify your poverty guidelines. Most of us use, I think, the federal standard in some form or fashion for that. You could also have a profile based on the needs of the community and the mission of the hospital as part of your policy. Before you write off your account, you need to make sure that you've exhausted all efforts to collect payment, either from the third party or from the patient. And make sure that you document the appropriate actions that you took to collect. To be deemed financial assistance eligible, some of the documentation that you would be required to provide, or the patient provide the prior tax return, your pay stubs, and bank statements. You can also include in your policy a presumptive assistance option. You just need to make sure that you specify how that is going to be determined and what evidence will be provided to have a patient be eligible for that. Catastrophic financial assistance, if the patient suffers a catastrophic illness or injury, then you might have in your policy something that addresses just that aspect of a patient's care. Medicare bad debts, again, I think we've talked about this a little bit, and it might come up in a section that Perry does too, but we need to make sure that we follow their guidelines for having a Medicare bad debt, making sure that you have pursued the case for 120 days, refer to an outside agency, and making sure that you're in compliance with all the regulations for Medicare bad debt.
I will say, guys, I've seen a few questions come out of this slide. So, you know, again, if this is something that you're not too familiar with, you may want to screen grab it just so you have access to it if it comes up on the test.
And then, of course, we have our underinsured and uninsured patients. I think we're seeing more and more underinsured patients versus the uninsured because of the ACA. The uninsured has been reduced. However, we are seeing a lot more patients with very high deductibles and on their plans. So being cognizant of that aspect of it and how best to assist the patient in making payments or offering discounts on those liabilities based on income or what have you. But I think the key is that it's all documented in your plan.
It's also important to make sure it's very consistent. You know, you kind of can't do this on a one-off basis unless there's a really good exception. Okay.
And then the Affordable Care Act requires the IRS to issue the rules to implement the financial assistance policy sections. So again, going to what Barb said, just make sure that you're consistent. It's all documented in your policy and you are following your policy when you're offering these benefits to your patients. Based on what you just read, what activity is not considered when initiating self-pay follow-up and account resolution activities? I think it's the top one. Yes, I got it wrong like 3 times when I went through it, so.
Got it.
So that one was a quick one.
That it was. So we're going to move on to 4.6. That's our next category. Christy, I don't know if I have a delay or if you have a delay. So if I'm speaking off the slide, just let me know. Okay, and I'll try to either slow down or catch up. The next 3 sections that we go through is chock full of dates, titles, key elements. So you might just want to pay particular attention to those items because chances are you might see a few of those on the test. So let's start with the ACA, the Affordable Care Act, which the 501R, which is this section, is a component of the ACA. And the first area of the ACA begins with the legislation. And the legislation of the ACA lays out 4 components. There is a community health needs assessment. There's policies related to financial assistance, which Kristen just spoke a little bit about, emergency medical care, and billing and collection activities. All hospitals that are deemed to be 501c3 hospitals, which are nonprofit, must adhere to these 501R regulations. The next section, again, I think I'm a little bit ahead of you, Christy, but that's okay. I'll talk very slowly. The 501R, because of the IRS's
Harry,
role,
after legislation, did you go IRS or revenue cycle impact?
I went IRS. I went clockwise. I messed that up last year. I went backwards, which unraveled the entire ACA by going backwards. In any event, the IRS, because of their role with tax-exempt organizations, are responsible for the regulations with the 501R. So I think it's important that you remember that the IRS is responsible for 501R. It was issued in December of 2014. It was deferred until December 29th of 2015. I don't know if this will be on there, but certainly the IRS question might be. The next bullet, compliance. You must comply with the 501R. It's a trade-off. In order to maintain your 501c3 status, which is tax exemption, there's a price to pay. So you have to comply with all the 501R regulations, which we will get into right about now. And I'm okay. So I'm kind of going along with you, Christy. So the objective of the ACA was to promote transparency of the hospital's community health needs assessment, financial assistance policy, and that policy is to provide protection to eligible patients with respect to charges and collections. And we're going to get into that now. Once we get into the, what are we into now? I'm moving my thing here.
I'm up to community health needs assessment.
Community health needs. Okay. All right. Community health needs assessment. And part of the financial assistance policy, everyone had to do a community health needs assessment. So you had to work with your community development area to determine significant health needs in your community. For instance, Montefiore Medical Center in the Bronx, their health needs are going to be much different than Northern Westchester and Mount Kisco, who's going to be much different than Ellenville and Sullivan County. So you have to be able to identify the health needs, prioritize those needs, and then identify the resources that are available to address them. And this information must be readily available to the community, and it must also include an implementation strategy and how you're going to identify those needs.
If anybody's actually interested, you could go to the website of just about any hospital system. The community health needs assessment is going to be listed there right next to the financial assistance policy. So you could go to your own organization's website and be able to look up this information.
Thank you. We'll move on to financial assistance policy. Each hospital is required to establish, or was required to establish, a written financial assistance policy, which applies to all emergency and medical necessity care. The financial assistance policy has 9 key elements. This is what you want to take note of. So in your policy, you must have defined eligibility criteria for all levels of your financial assistance, whether it be 100%, 80%, and so on down the line. You must let the patients know how you're going to use information that you've gathered from sources other than the applicant, whether it be phone bills, leases, and so on and so forth, because there's certain information required just beyond the charges and your income. So that has to be communicated to the patient. How an individual actually applies for financial assistance and all their documentation, that has to be clearly laid out in your policy. Where an individual can obtain assistance when completing the application. A listing of all providers covered in the financial assistance policy and those who are not. These are all key elements of the policy. A notice that individuals will not be charged more than your amount generally billed, okay, and amount generally billed to insured patients. And the next bullet will get into that a little bit more. Amount generally billed, I think I skipped one. Okay, so there has to be a prohibition on billing financial assistance policy eligible individuals gross charges. Okay, they can only be billed, the average generally billed for those components of the bill that are patient responsibility. So if you have insurance and your insurance pays and you have a high deductible, the balance that might be your responsibility will then fall into your financial assistance policy, should you qualify. And here's where they get into the AGB. There are two methodologies for your AGB. One is considered a look back, where you would take your previous 12 months history of approved charges, and you can either do a Medicare mix, you can do Medicare by itself, Medicaid by itself, you can mix in insurance carriers as long as you're consistent, and you would take the averages of 12 months and that would be your AGB. Or you can do it prospectively, where you'd use a Medicare Medicaid fee schedule going forward and apply your AGB fee schedule under that methodology. So there's two schools of thought, as long as you're consistent, which whatever you use for each patient. And the last is what actions the hospital is going to take in the event that you do not make payment under the financial assistance policy. So those are the 9 components that must be in the written financial assistance policy. Another part of the policy is it has to be publicized widely. Okay, it has to be, there are 4 areas. It has to be in plain language, summarized in plain language, and must be available on the hospital's website. Christy just mentioned that earlier. A hard copy must be given to each patient either during registration or upon discharge. Notices must be posted throughout the hospital areas where registration and discharge occur, and it has to be publicized and available within service areas. So it has to be readily available within the institution. It also has to be in various languages. And so if you have a population in your catchment area that services a number of patients that's either at least or lesser than 1,000 individuals or 5% of the community. So if you're in a Asian community that takes in more than 5% of that population, you must have your policy in their native language. Okay, extraordinary collection actions. And this is part and parcel with your financial assistance policy or just your overall collection policy. So there are 4, I believe there are 4 types of extraordinary collection actions, and here they are. One be legal actions such as garnishment, liens, and judicial processes. Selling the debt to a third party to get a more aggressive collection effort. Reporting information to credit bureaus, or deferring or denying service for non-payment, which generally doesn't happen or does not happen in New York. It could happen in more of a for-profit environment, generally down south or in the Midwest with the big health systems. But again, this is a national test, so this is part of the extraordinary collection.
But just remember back to EMTALA, you can never deny emergency room services. I don't care how much they owe you. I don't care where you are.
Or active labor, and that's national. That's or active labor as well.
Correct.
Okay, reasonable effort examples. So what constitutes a reasonable effort, which must be undertaken prior to initiating ECAs? You have to publicize your financial assistance policy. You have to wait at least 120 days from the date of the first post-discharge billing statement for initiating any extraordinary collection action. You have to provide written notification about your policy, including a copy of the plain language summary. 30 days prior to initiating any collection action. So you have to give your patients, you have to communicate with them before you place them, if you will. You have to allow potentially, and this is interesting, potentially eligible individuals to submit their application at least 240 days from the date of the first post-discharge. So if they're potentially eligible when you screen them at registration, they have 8 months from the first billing statement to file. So I would imagine most institutions have a pending charity designation that they have their receivable in, which they would then clear out after a certain period of time. You have to notify any individual who submits an incomplete policy application during the application period on how to complete it and what corrective action they have to take, and you have to offer an assistance. These are examples of reasonable efforts prior to placing someone or taking extraordinary collection action. And protections. So protections to the patient. Anyone submitting an application within the 240-day period receives specific protections. The hospital is required to suspend any collection action. So if you place them and they say, well, I want to apply for charity, you have to recall that account, as an example. The hospital must review, or the organization must review the application and provide a determination in writing to the patient, including description of any assistance which the patient may be deemed eligible. If the patient does not qualify for 100% free care, they must provide a billing statement indicating the amount owed and how it was calculated. So if you have a sliding scale, you must indicate that on the bill. And if the patient has already paid the hospital any amount in excess of what they might be eligible for, you have to refund them. And if any, now I'm going back to another screen. So any collection activity already been initiated, such as reporting to a credit bureau, that must be removed from the patient's credit report. Where are we? We're up to revenue cycle impact, Christy. Is that where we are?
That is where I'm at.
That's where we are. Okay. So the financial assistance policy, or the 501R, I should say, does impact the revenue cycle both on the front end and on the back end. So on the front end, okay, your team, the individuals must initiate those financial conversations as soon as possible, whether it be during scheduling, pre-registration, but no later than at the time of service. Okay, and then Hfma goes on to they have best practices for financial communication, which I think we covered in some previous slides. But then there's also a back-end piece. The back-end staff must manage the financial assistance policies. They must make sure that patients are not being billed beyond the AGB. And if you think about 8 months of allowing the patient to complete the application and make a determination, it's a big impact on the revenue cycle on the front end and the back end. It's resource intense. So just think the revenue cycle has a front end impact and a back end impact. And so we finished that little circle of life. What are we moving on to? Oh, checkpoint. I'm never good at this. Okay, an option not required. Oh, I'll wait for you, Christy. Come on, move it along.
I'm going with out-of-network providers.
Oh, I don't even see that. Okay, so you already went that way. Okay, yes. I'll let you click the I'll give you. Okay, so you got that one, the out-of-network.
Yes, I am now on 4.7, patient debt regulations.
You are?
I am.
Okay. Boy, I'm way behind. Anyway, I'm going to go through this section relatively quickly because, again, we're going to talk about credit agencies, truth in lending, garnishes, bankruptcy. Really, it's just numbers and definitions. So we'll start with right here, granting credit. We won't get really into the weeds on this one. We'll do it very high level. But as far as granting credit is involved, there's a Consumer Credit Protection Act. And underneath the Protection Act, there's 4 acts, if you will. There's your Truth in Lending, Restriction on Garnishments, Fair Credit Reporting Act, and Fair Debt and Collection. And we can, again, we can touch on each one of these. Christy, if you want to move on. I'm trying to catch mine here, so just bear with me.
Sure.
Okay. Oh, you can go right ahead. Bureau. Whoa. Okay. Is the I didn't see it move on the screen, so
On Title I, Truth in Lending Act.
You are on that one. Okay. All right. I'm just, my screen hasn't moved, probably because my internet's up. Okay. All right. So I'll work on, I have another screen open here. So the Truth in Lending, Title I of the Consumer Protection Act is called the Truth in Lending. It establishes disclosure rules, and underneath the Truth in Lending, there's a Regulation Z, which lays out those disclosure rules, and then it goes beyond that to lay out some criteria even further. So if we click on Regulation Z, okay, there are 5 disclosure requirements. I won't go through each one of them, but you might want to make note of these for the exam. There are 5 disclosure requirements that apply to all hospitals if all 5 of the points are met. Now, if we move beyond this, again, I'm going to go relatively quickly. There are 4, 7, 9 additional points that are under the Regulation Z. And if you click on, well, when Christy clicks on each one of them, they will become very familiar, because if you could think about your credit card statement, for those of you that get the statements, on the back, they lay out your rate, the finance charges, the amount financed, how much you would pay in 3 years, how much you would pay if you made the minimum payment, and so on. So these are all disclosure regulations, and they apply both to hospitals as well. So I would take note of the Truth in Lending, take note of the Regulation Z, the 5 components. You probably won't get this far into it, but the 5 components of the Regulation Z, it may touch upon. Okay, Title 3. Are we on Title 3, Christy?
Title III, restrictions on garnishment.
Okay. Restrictions on garnishments. There are the formulary. If you're going to get your wages garnished or any kind of a garnishment, and the examples right here, 25% of workers' disposable earnings or wages not to exceed the federal minimum wage. So again, just familiarize yourself with this. They're probably not going to get into financial examples, but just know that there's a Title I, a Title III, a Title VI, and then Title VIII. We'll get into the Title VI next.
Yeah, it's not important to know what this formula is. It's just important to know what a garnishment is.
Right.
Title, what is that? Title VI, Fair Credit Reporting Act?
Yes, the Fair Credit Reporting Act, and what it allows, it's dispute of accuracy of information. Reinvestigation doesn't clear the dispute. The consumer may place on file a brief summary. So in essence, it gives the consumer an opportunity to dispute any information that's on their credit file that is either erroneous or a little suspect. So it's fair credit reporting, and all the onus is on the reporting agency. And then the last one is Title VIII. Title VIII is the fair debt and collection practice, which is the actual collection of the account. And underneath that, there's 4 components. There's Section 804, 805, 806, 807. Christy, if you want to click on those, I'll just go through those very, very quickly.
804?
Yeah, 804. You can go right through them.
Oh, okay. Okay.
Okay. 804 governs the actions of debt collectors while attempting to identify. So if you're trying to find a patient, okay, you shall, and if you click on that, you have to identify him or herself. And after the consumer is represented by an attorney, regard the subject debt, has knowledge, you can readily ascertain, information about the attorney and so on. You cannot disclose any information when you are trying to find a patient. You can't leave information on an answering machine, cannot communicate by postcard. So there's certain things you can and cannot do under Section 804. 805 again talks about basic functions of collector communication. When you're dealing with the consumer, certain steps that you can take. Okay, you cannot, at any unusual time or place known, which should be known to the inconvenienced consumer in the absence of knowledge. If the consumer is represented by an attorney, you have to speak to the attorney. You cannot call the consumer's place of employment if you know specifically that they cannot receive calls there. And then you have to cease communication under these situations that the debt collector further efforts are being terminated. Notify the consumer. The creditor may invoke specific remedies and intends to invoke, where applicable, to notify the consumer, invoke a specific remedy. So again, you probably not going to get into the specifics of each section, but you just might want to take note of them for the exam. Section 806 speaks about harassment. You can't threaten, use obscene language, and so on. So we'll go beyond that. And Section 807, false representation. You can't call up and say, I'm an attorney and we're going to sue you and take your house and so on. So you can't misrepresent yourself to the consumer. So again, these are the titles. Just take note of each title and the name of the title. Probably not going to get into specifics, but the 804, 5, 6, or 7, they might.
And those are good things for you to know, just for your own self. I actually had a friend who received an incredibly nasty voicemail on her home answering machine about an unpaid bill. And the language that was used was so highly inappropriate that I was able to refer back to those different acts and say, you know what, they're not allowed to do this. So just for your own self, it's good to know, it's covered under those different titles.
And it's important to understand, a lot of times when your revenue cycle makes decisions to not put something in collection or do whatever, a lot of times it's because of this. If you don't make certain collection efforts, you may feel like, you should, or why aren't they going after it? But sometimes it's to avoid some of these very tough regulations to follow.
Okay, Consumer Financial Protection Bureau. Just remember that this is an agency of the United States government responsible for consumer protection in the financial sectors. Now, do you need to know it's authorized by Dodd-Frank, Wall Street Reform and Consumer Protection Act? I don't know. But yeah.
I would generally say I've not seen Dodd-Frank, Wall Street Reform on the
chart. Not, huh? Oh, okay. Well, it's going to be on the next test.
Of course.
Okay. An activity. We have an activity?
I do have an activity.
You do? Okay. All right. So we'll go through this one pretty quickly. Title 1, the Truth in Lending. Title 3, Garnishment. Title 6, hope I get this right, Fair Credit Reporting Act. And Title 8 would be Fair Debt Collection Practices. Chrissy, am I ahead of you? I'm sorry.
Nope, we were together on that. And it looks
we
like
were? My screen is not moving, so I'm not doing well. Good job, though. Okay.
We're up
so
we're going into bankruptcy
now?
We are.
Okay. Bankruptcy, you have 3 bankruptcies. You have Chapter 7, Chapter 11, Chapter 13. Very simply, Chapter 7 is a straight bankruptcy, and it's a liquidation. Generally, the debtor would put themselves or file for a Chapter 7 bankruptcy, and they would make a list of all their assets, all their liabilities. They would be granted, it would be approved, I guess, if you will. But there are certain things that cannot be, and then there's a trustee that usually sells off the assets. There are certain assets that are excluded. Okay, I'm just trying to get that list. Yeah, because I'm a little bit behind here. So following property is exempt. So a trustee will not sell off any real property, mobile home, co-ops during a bankruptcy. Any disability benefits, life insurance, things of that nature, they're not going to garnish, they're not going to use that to pay any creditors. Alimony or child support, any retirement benefits, those are not going to be taken into account when they try to satisfy any outstanding debt. Other personal property, animals, clothing, musical instruments. I mean, there's a litany of things. They're not going to kick you to the curb and just satisfy the creditors. Other public benefits, crime victims, public assistance, Social Security, wages, tools of the trade, you know, basic necessities of life, they're not going to take. Items that cannot be discharged in Chapter 7 are back taxes, debts that arise from under false pretenses, debts that are not listed properly, debts resulting from a bankruptcy's misconduct, so if you committed fraud or embezzlement, unpaid alimony, debts from personal injuries, so if you were driving a car, God forbid, and you hit someone, you incurred a debt, they're not going to discharge that, government fines, education loans, and also debts that could have been listed in a previous bankruptcy or debts that were discharged or waived in a previous bankruptcy proceeding. So there are exemptions to the discharge, and there are also personal property that are exempt from the bankruptcy. So you just might want to make note of those. Chapter 11 is a reorganization. Basically, you would apply for a Chapter 11 reorganization, and within 120 days, you would submit a reorganization plan to the courts. The courts would then send it to your creditors. You would provide a list of creditors. The creditors have the option of accepting the plan or denying the plan. And generally, the plan has to work in favor of the creditors. So it could be where your reorganization plan might be 20% of existing debt, 80%, whatever the case may be. The plan is accepted when there's a majority creditor approval in number and 2/3 in the amount of claims. So it gets to be a little funky when it comes down to approval. But I would think, just remember, because I've seen this on a couple of sample tests. Chapter 11 is reorganization, and it's 120 days that you have to file the plan. So if you remember those 2 things, I think you should be okay. And then there's Chapter 13, which is basically rehabilitation. So in this case, there's no liquidation and no discharge of debt. Basically, you are restructuring your debt, if you will, okay? And garnishment is a form of debtor rehabilitation, which is a structured payout. Okay, bankruptcy. It's important just to make sure that bankruptcy claims are properly identified and promptly identified, and notify your agencies, because then they have to cease all activity on anything that, if you either granted any of the bankruptcies or if you filed, you have to cease all collection activity. And they generally come in the form of a court order. something written on a napkin by a patient generally doesn't qualify, which we've seen. A credit priority, I won't get into the formulary, but a credit priority in the case of usually in a reorganization, it's a secured claim. So if you had a contract with an organization that was filing for bankruptcy, you would be considered a secured creditor. If it was a mortgage, if it was a third-party lien, whatever the case may be, you would be considered a secured creditor. If you were a vendor and you supplied them with 3 cases of something and there was something in accounts payable, you're an unsecured creditor. So creditor priority are those creditors which have a monetary assurance of payment of debt, which is the way it's laid out here on the slide. We into the checkpoint now. Okay, which option is not a bankruptcy type governed by the 1979 Bankruptcy Act? And that would be credit priority. So you have straight bankruptcy, debtor reorganization, and rehabilitation. Credit priority is just a creditor's status. And that is correct. Okay. I still got collection agencies to do. All right, moving along here.
I'm up to
Okay.
the Telephone Consumer Protection Act.
Yeah, I think in the interest of time, with everyone's permission, maybe we'll just go past this. Okay, I think everyone can just read up on the Telephone Consumer Protection Act. Basically, it deals with robocalls and auto dialing in relation to collection agencies. So I think we can pass this. I think if we get into collection agencies, we still have to talk about outsourcing, and then we should be done. So I don't hear any screaming from the audience. So Chrissy, if you want to jump over to where are we? Collection.
4.8 medical
4.8.
account resolution.
Yeah.
I just want to remind everybody, if you do have a question or there's something you want us to go back to, this is your class. Please put it in the chat and we will make sure we do that.
Right. Or after tonight's session, if you want to just talk, you have a one-off question or you want to go one-on-one, that's fine too. So don't think this, this is not the end. This is just the beginning, as they say. Okay. So where are we? Medical accounts receivable?
Medical account resolution.
Medical accounts receivable, yeah, okay. Let me
We
fix
want
my glass.
we don't want receivables now.
Oh, God. Okay. So as it says here that there are other account resolution activities in only after the account is determined to be at risk for bad debt. Okay, the benefit of account resolution providers should really take responsibility for educating patients on their options and responsibilities. Again, it goes back to communication of your financial assistance policy and your just overall policies on the front end. Okay, HFMA's best practices. Okay, so as part of your collection agency or just your overall collection effort, you want to make your patient bills friendly. Okay, and HFMA does have a patient-friendly billing project that I think they've completed at this point. You want to establish your policies and ensure that they are followed. All activities pursuant of account resolution should be governed by the provider's organization. You want to be consistent with your policies. Make sure your policies are clearly defined and they're enacted consistently throughout the organization. You want to coordinate your account resolution activities with business affiliates, so you don't want any redundancy. So if you have an agency that's doing an early out or someone else is doing an early out, you want to make sure that you coordinate the activities with those affiliates. Exercise sound judgment when choosing account resolution methods. So if you're in a a highly populated area taking advantage of your financial assistance policy, you want to make sure that you're exercising sound judgment when you're trying to collect on outstanding debt, because there might be no opportunity to pay. So just be conscious of your community, if you will. You want to start the account resolution clock when the first statement is sent. Okay, again, best practices in the 501R regulations specify that providers and business affiliates should wait 120 days from the first bill. Report back to credit bureaus when the account is resolved. Okay, make sure that if the patient does pay, and you have reported to the credit bureaus or the collection agencies, that you communicate with them. Any more? Yep. And then track all your consumer complaints. All complaints should be tracked and shared between the providers and business affiliates to improve customer service. Okay, choice and use of collection agency. Okay, I think it's, we use collection agencies because they have better luck at collecting on potential bad debt accounts. So although there is a reluctance, it's a necessary evil. So let's move right into the selection of an agency. Are you on that slide, Christy? Because I think my computer is slow.
I am on selection of a collection agency.
Oh, okay. Well, my computer is not slow. I think it's dead. Okay. Selection of an agency is similar to an affiliation with the business partner. Okay, specific Hfma business associate agreement should be included within the contract between the agency and the provider. Okay, I'm moving on to evaluation.
Evaluating a collection agency.
Evaluating a collection agency. Okay, and there are 6 components when evaluating an agency. First being reputation. Agency should be capable of providing 3 to 5 references. An agency that does not have a variety of healthcare clients will not be fully experienced in the language and the background of healthcare collections. This last paragraph is probably going to be a question. Ideal collection agencies will have individuals on staff, even at the manager level, who have documented experience working in the financial areas of a medical group, hospital, or healthcare provider. So I would pay close attention to that. Oop.
Did you go to patient relations or collection results next?
Okay, I lost myself. Oh, there I am. Bear with me. Okay. Patient relations, again, I'm going to go through quickly. Medical collections, as you know, is an emotional and sensitive issue. So your agencies must try to maintain that patient relationship, manage the collections efficiency, and they should be trained and experienced in your policies. Agency fees, net dollars recovered is the total cash collected by the agency less the collection agency's fees. Okay, pay attention to that because that might be a question on there. I'm moving quickly. Anybody has a question, feel free to use the chat box.
I clicked into small support.
Retention. Agencies should specify how monies will be handled that are sent to the agency. It's standard practice for the agency to accumulate payments in a trust account, make monthly disbursements to the client, and they typically will net their fee out of those funds. Reports, 2 types of reports that the agency should provide. One is an assignment report, whether it be weekly or monthly. Whenever they have a placement, they should give you an acknowledgement report, an assignment report, and also a monthly collections report. Those are the 2 reports that you should get, must get from your agency, aside from any other ones you may request. And results. should understand how the agency calculates their recovery percentage. Okay, most agencies will take into consideration, they'll take their gross placements and they'll they'll take out any recalls, if you will. Okay, and here's an example right here. The cash recovered, and they'll come up with a percentage. So here you place 300,000. The client recalled 50,000, leaving a net assigned of 250,000. Collected 10,000, so they had a 4% recovery. Any formulary that they use is fine, not any, but within reason, as long as they're consistent in the formula each time. Okay, I'm on to working with the collection agency.
Me too.
All right. Accounts should be transferred to your agency on a regular basis, whether it be weekly or monthly. And the staff working with the agency should adhere to their firm set of policies and procedures on how and when an account is assigned. So if you have age criteria, if you have dollar threshold, small balance write-off, you have to be consistent and you have to adhere to those policies. We're on staff now. Should assign a staff member. One staff member should be assigned to be the contact for the agency. Provider will enable an open line of communication. That staff person should have the authority to place accounts with the agency, whether it be based on dollar value. Accounts that have larger dollar amounts could require a higher ranking, so that person would communicate the information back to the agency. And there should always be ongoing reviews, and certainly any variations in commissions paid should be looked into. There are things known as second placements. Basically, if your primary agency can't collect, some organizations will use a secondary agency. It's almost a check and balance. I'm not going to get too much into this, but there are things called second placements. And basically, it's a second agency that you would use. Law firms, okay. You can use a law firm as a substitute for an agency. Generally, law firms will specialize, use a law firm that specializes in bad debt account collections. Some law firms might have a division that specializes in that. It might be solely specializing in healthcare. Evaluate the law firm the same way you do a collection agency. You can use them as one-offs on high balance accounts, accounts that require litigation, accounts that are time sensitive. So there's a myriad of ways that you would use a law firm, but you can use a law firm as a substitute for an agency. And then we have our activity. There are 6 questions. We can go to them very quickly. Which evaluation criteria demonstrates reputation expectations? Employment of staff who have documented experience. And there's no way to get through this fast. Agency fees are the cost of the provider for collection agencies' monies offset by the return on bad debt.
Gary, if you don't want to go through all these questions, we could skip to 4.9.
Oh, if you can skip them, by all means, go right ahead. Go ahead, skip away.
Okay, guys, and we're going to run a little long tonight just because we want to get this covered and for you, and we are into our last section.
And I will end our last session with outsourcing within the revenue cycle. So outsourcing within the area of accounts receivable involves using outside resources to manage all or specific sections of the accounts receivable functions. There are vendors who, for a fixed fee, assume responsibility for aspects of accounts receivable up to and including. So you could use an outside agency to help with any one of these or all of them, depending on what your institution needs. You could do appointment scheduling, registration, charge posting, billing follow-up, and assignment to collection agencies for additional follow-up. Okay, so outsourcing programs. Any function within the revenue cycle may be a candidate for outsourcing. So if we could look at the different functions, so the first one would be patient access. So within the patient access area, a call center vendor may be used to handle scheduling or pre-registration activities on behalf of the hospital or the physician group. In this case, the technology needed to effectively manage a call center would be deployed to ensure low patient wait times and maximize the utilization of the resources within the health system. Then you have your health information management. So in the HIM area, other examples of outsourcing opportunities are transcription, coding, and release of information processing. And then you have your patient accounting. It's a call center approach is also a viable option for the processing of insurance and self-pay account follow-up. You can use automated dialers, randomized calling schedules for the self-pay accounts, and you can increase productivity and collections. And then another advantage is the ability to make calls during appropriate evening hours and weekends, which hospitals traditionally do not do or haven't had their staff required to do so. So like anything, there's advantages and disadvantages of outsourcing. So we'll look at some of the advantages. So we can select each image here. So the vendor may have access to qualified staff not available to that particular healthcare facility. The vendor may have access to technology that is not cost effective for individual healthcare to purchase and then maintain. The vendor limits the need for internal requirements for hiring, training, and supervising staff. The vendor can absorb financial risk if the cost of handling accounts receivable increases or includes an efficiency factor. And then the vendor capitalizes on economies of scale not available to individual healthcare facilities by handling accounts receivable in a central location for a number of groups. So some disadvantages. Some disadvantages of direct control of the accounts receivable may be impacted. Customer service or patient relations could be impacted. If the vendor is not effective, there could be increased costs. And legal considerations must be reviewed if the outside vendor staff represents themselves as employees of the healthcare facility. Do you want to skip the activities, Christy?
Up to contract clauses.
Yeah, okay, perfect. Just in the interest of time. For a health facility protection outsourcing contract should contain specific clauses. So if you select each letter, it will tell you what the clauses should be. So an annual renewal clause and a cancellation clause in the contract. Clear understanding that the provider retains ownership of any outsourced activities unless specifically sold in the vendor contract. Procedures and protocols for the outsourced services and activities ensure segregation of outsourced and insourced responsibilities. A trial period of 3 to 6 months from the initial outsource date to allow resolution of unexpected problems. Specific language as to who will pay the cost of legal action if needed. A specific statement as to what areas of responsibility will be outsourced, including specific job descriptions if individual jobs are outsourced. Frequency and types of reports that will be generated by the outsourcing vendor. And a statement on how the vendor is expected to protect the confidentiality of all information that comes into its system. So again, just make a note there, but these are all very important to have in your contracts with any vendors you may partner with.
And it's very important to realize that even though you may outsource your billing or your coding or whatever it is, that ultimately the hospital is responsible for the correct information being sent to the insurance companies and government agencies. So having a monitoring system and knowing that the vendor you're using is, doing everything in a compliant way is very important. It doesn't say that in that little thing of contracts, but you should have something in there that guarantees you or gives you assurances that they're doing everything, you know, compliant with regulations, et cetera.
Yeah, I mean, related to that, any contract, any vendor that you have coming in doing any of this outsourced work for, you do want to monitor them. You also want to audit that work. And because Barbara's right, you as the provider, you're the one who's ultimately responsible. If Department of Health comes in and does an audit, they're going to want money back from you, the provider, not back from your billing vendor. So when it comes to these contracts, when it comes to the services that you are outsourcing, make sure you have a good audit process in place to know that vendor is being compliant. It is your job to make sure they are compliant.
Yes, and you are correct. So there's some key points to remember, and we went through that relatively quickly. So if you do have any questions, again, feel free to let us know. You can reach out separately as a group, whichever you prefer. So just, I know we've gone over this. Take the test relatively soon after this course, you know, brush up on your own, study a little bit, and then take the assessment. Christy has her screen up here, which is, you know, helping you get more prepared to take it, but I say this, I still have to take a certification that I studied for in October and November, but make sure you take it relatively soon. And again, we're here, and reach out to us, let us know how you did. We like the feedback, whether it's a pass or fail. If you won't get the questions you answered wrong, but you'll get like the where you did best and where your weakest points were. So, you know, reach out, will certainly help. We can always refresh those weaker points. You know, that's what we're here for.
So to that point, let me give you guys a quick run through of the test. The test is actually built into your guide. So it is this thing, you know, this option down here, CRCR, 75Q assessment. So it is a test. It can comprised of 75 multiple choice questions. You are going to get an hour and a half to complete that test. After an hour and a half, if you have not already submitted the test, the system will submit it automatically for you. So that's something you want to make sure when you sit down to do the test, to make sure you leave yourself an hour and a half. Make sure you have a really good internet connection, because if for any reason while you're taking the test, if your internet cuts out, the test will submit wherever you left off, whether that's one question in or 60 questions in. So make sure good internet connection, leave yourself that hour and a half. You cannot, when you're in the test, you cannot go back up here and click and say, oh, let me just go to 4.1 for cash posting to get that answer. That you are not allowed to do. If you do that, they will consider you out of the test, and that it will submit with however many questions you answered. So just be careful of that. Know that you know, you can have your papers in front of you. The notes that you can have those in front of you while you're going in to take the test. If for some reason you don't pass the test the first time, don't get discouraged. Then at least you'll have an idea of the questions that they're asking. Like Christina said, you do get a report at the end. It will tell you what sections you did well in. It'll also tell you in what sections that you didn't do so well in. So that gives you a good opportunity to go back and review those areas. And like I said, once you see the questions a few times, you get a better understanding of what types of questions are going to be asked and what information you need to know. Kristen, anything to add?
Yeah, one other thing, you have the option to flag a question and go back to it. So when you read the question, if the answer doesn't jump off the page, I always suggest just flag it, get through the exam, and then go back and revisit those questions that you flagged. Don't take too much time on something that maybe might be one or two specific answers. So I would try to get through the easy ones and then go back. You do have an option to flag them, and then you can just make a list of those that you flagged.
And I also think it's, we said it at the beginning of the study course. This is an overview. Okay, you really do need to open your guide. And I'm not saying that you've got to, you know, memorize every word or whatever, but you definitely want to refresh on things that you're maybe not that familiar with, or something that strikes you as, wow, I didn't know that. You really want to go through your guide and go through those key points. But to Christy's point, don't put it off too long, you know, like do it while it's fresh in your mind. There's no embarrassment in failing. If you fail, you get to take it again. And we're happy to help you wherever we can.
And the good news is, if you fail, we promise no email, no text, nothing goes to your boss letting him know that that's what happened. So there's absolutely no downside to making the attempt.
Yeah, you just have to wait 30 days to take it again, though, correct?
You do have to wait 30 days between test attempts.
Right.
So if anybody has any questions, feel free to go ahead and throw them up into the chat, and that way we'll get those answered for you. Other than that, thank you for participating in our study group, and we wish you the best of luck taking the CRCR.
And
Oh,
definitely
one last thing. I know we had some technology challenges with recordings. We weren't able to capture every session, but those that we did capture, we're working with the region to try to get them out on YouTube. Once we resolve that, we'll share them with the group. So I don't know when, but we promise we'll do that. So
it will be quick. You know, they're working on it. They can, you know, get them loaded pretty quickly. So
yeah, they're very large, and I think we have Barbara's vacation pictures in there too.
Remember, I had no vacation this year. All right, listen, happy Thanksgiving to everyone on the call. Please enjoy your families and be safe. You know, listen to those numbers, and you know, Zoom is a good option. It's certainly better than some of the alternatives.
Okay, thank you all.
Bye, everyone.
All right, thanks everybody.
Bye.
Bye-bye.